Thanks, Jim. I'm going to cover proceeds of crime. Now, proceeds of crime in itself could probably take up all 4 seminars today, but you'll be relieved to hear I'm going to focus on only those aspects that relate to regulatory offences. Title, for that reason, corporate crime doesn't pay. Well, I think we all know that that's completely untrue. Corporate crime pays very well, thank you. And one of the key aspects here is to look at why it is that proceeds of crime is being used more and more in relation to regulatory offences. And it is beginning to come in, certainly in environmental, certainly in consumer law, trading law, advertising, and moving on questionably to safety. It's certainly being attempted in a number of cases in which I'm going to refer to in due course. So just to set out the scheme here, confiscation. This is the generic term. The Supreme Court has described it as being a misnomer. Certainly my initiation to all of this a few years ago in a consumer trading case. I'd spent hours working out a basis of plea with the prosecutor in the usual way. And then as a throwaway line at the end of his call, he says, and of course I'll be making an order for confiscation. Now the case happened to do with misleading descriptions of beds and the way that they're being marketed for elderly clientele. And so I thought at first, confiscation, surely they don't want to confiscate the beds. And then it dawned that he was actually referring to the Proceeds of Crime Act. And of course, when we went through it, that was precisely what he was going to do. Had he pursued that course, the deal would have been completely off the table because the contributions that would have been sought in that case would have been far greater than any fine would have been imposed. And certainly my client wouldn't be very interested in that deal. The reason it's talking about confiscation is that all of this legislation stems, as you may be aware, from the Drug Trafficking Act and attempts to get money off drugs, drug traffickers and money launderers and fraudsters and so on. But really the essence, and this is something the Supreme Court have come back to in a very recent case, is looking ultimately to deprive offenders of the financial proceeds of their conduct. And it's not intended to be a further financial penalty, an additional fine or a punishment or a deterrent in itself. Now, whilst that may sound obvious and straightforward, proceeds of crime is the title. Nevertheless, when you see some of the cases, you start to wonder whether actually the intention is to get proceeds of crime at all. Now, the other aspect to it, which has caused a great deal of consternation, is something that I'm going through in a couple of cases, is that the exercise is not confined to just a sentencing. The prosecution can seek a restraint order to freeze assets even before anyone's been charged with an offence. In other words, to ring-fence and protect assets that they think they're going to successfully seek confiscation of at the end of criminal proceedings. So why is it important? Well, it's no longer a situation where this is all just to do with grubby fraudsters and drug traffickers. We like to think as regulatory lawyers that we're a bit above all of that type of mucking around, but it's not the case. There's no distinction in the Proceeds of Crime Act between real crime and what was once described in the case of Janway Davis as being quasi-crime. And that's pretty clear from the way that His Honour Judge Baker put it in St Albans, endorsed by the Court of Appeal relatively recently, a couple of years ago. And this was in relation to that heinous activity of disregarding planning enforcement regulations. And he said, well, those people are at risk of having the gross receipts of their illegal businesses confiscated, and it may exceed their personal profits, something I'm going to come back to in a moment. In this respect, they're in the same position as thieves, fraudsters, and drug dealers. Well, I might remind His Honour Judge Baker of that when he seeks an extension to his property. But that said it all, there is no distinction, and it is causing an enormous amount of litigation. We've seen very recently a Supreme Court decision which has then triggered a whole raft of Court of Appeal decisions. And I just put in the dates, the months of the last 3, just to make the point that this is stuff that is producing case after case before the Court of Appeal, and that is going to continue because not only is the legislation complex, it's so fact-sensitive, and particularly when it's applied to regulatory cases, that it is bound to generate appeals, and particularly in the harsh way that it often results. So just as a quick summary of the basics, what are the benefits that are being sought? Well, it's property. It's all property or a pecuniary advantage, and a pecuniary advantage being something where you've gained a saving of some sort, and I'll come back to that in a moment. I just put the point in about what is property because it's always amusing to see it defined, and defined in this way. The Supreme Court sniggered at this as well, that it's anything somebody holds an interest in, and then they've even defined interest as well, which is always helpful. But the procedure is, and this is the aspect which is quite surprising about this whole legislative approach, is that really, once the gun is fired by the prosecution, the judge has very little discretion to stop the process. And so the key aspect is really to avoid, if you can, the prosecution making the application under the Proceeds of Crime Act. Because once the process is underway, the legislative wording is all along the lines of must and shall and so on for the judge. Now that is qualified, been recently qualified by the Supreme Court according to the European law test of proportionality. And I'll mention that in a moment. But the judge has very little discretion. And what the judge must do first of all is decide it in this order. The judge has to look at whether the defendant has a criminal lifestyle or not. If the defendant has a criminal lifestyle, could be a company, does it have a criminal lifestyle, then a series of statutory assumptions will follow. If not, then it's for the prosecution to prove that the particular offence has given rise to a particular benefit. It has to be much more exact. In terms of those statutory assumptions, if there is a criminal lifestyle established, then this is assumed by the court unless the defendant can prove otherwise, according to the balance of probabilities. Any property transferred to that defendant within the last 6 years was obtained as a result of criminal conduct. That's a pretty enormous assumption. Any property held by him, the company, it could include, after conviction was obtained as a result of general criminal conduct. Any expenditure incurred was met from property, and that property was all free without any interest on it from anybody else. So what is a criminal lifestyle? I mean, we all presume it's something like putting people in the back of a car, or drug dealing, or buying fur coats with the proceeds of crime, but it's not. Section 75 defines a criminal lifestyle in a way that will attract a lot of regulatory offences. It's an offence committed over a period of at least 6 months, and the defendant has benefited from the conduct which constitutes the offence, and that benefit is more than £5,000. Now, if you fall within that category, that's a criminal lifestyle. And when one thinks of regulatory cases, many of which are a continuing offence over a period of time, you can see that that can actually fall within the criminal lifestyle provisions quite easily. Now, the counterbalance is the Human Rights Act, much derided but now prayed very much in aid by us regulatory lawyers, and it puts forward a balance that the Supreme Court has really endorsed, which is the Article 1 and the first protocol, the entitlement to peaceful enjoyment of your possessions, balanced against the state's entitlement to seek to enforce its laws and to secure the payment of any penalties. And that is going to be really what the court must be focusing on in each case to determine whether the confiscation is proportionate or not. So, enough of the general talk. This is a case study. It's environmental, and it's a case that was decided in the last couple of months. Court of Appeal. And it's followed on from the Supreme Court decision, so this is bang up to date. The defendant is a landowner, has imported onto the land, his land, supposedly waste for reclamation purposes, effectively to build a hard standing on that land. The court accepted, and this is a key aspect, seems to me, that no monies were received for those waste deposits. So he took on waste deposits to build his hard standing, but didn't take any money from those who were depositing the waste. The defendant pleaded guilty because he had done all of this without a licence, a permit, and therefore was in breach of the law. And so, as per usual, this could be so many environmental cases that you do, faced a fine, prosecution costs. All straightforward. But the EA pursued confiscation proceedings on the basis that what this person was effectively doing was running an illegal landfill, burying this waste on the property and evading having to pay landfill tax, which he otherwise would have done had it been taken to a landfill site or if he was setting up his own landfill business. So what's the outcome? Well, there are a number of different options that it could have been. The court could have concluded that, well, he didn't receive any money for those deposits, so he didn't derive a benefit from this activity. He did receive a benefit, and that's the saved cost of not actually buying a permit in the first place or acquiring a permit from the EA. Or that he did receive a benefit because it's the saving of not having to pay landfill tax or anything else. As you can see, the difference in terms of figures is enormous. And the answer, as the court found, was answer C. And so in that instance, somebody who was, I'm sure it would have been argued there was an environmental cost of what he was doing, but not an enormous one. And in circumstances where the court had accepted as a finding of fact he hadn't actually received any money for what he was doing, was nevertheless found to owe, in terms of confiscation proceedings, $156,000 as a consequence of that. And one can see that, apply that to a number of other cases, this could have an enormous effect were it to be applied at the end of a case, and it has in some. So that's the decision, Morgan, as I say, very recent decision. And the reasoning was this, is that the whole activity was unlawful because it was conducted without the necessary licenses. He had evaded tax, and he had obtained a pecuniary advantage. And really, this man is no different to somebody who smuggles cigarettes into the country without paying any duty or VAT on it, or somebody whose garage is accepting deliveries of fuel without paying the relevant duty. It was argued in the case, well, it is different because in those circumstances, there's a mens rea there. The person is deliberately intending to avoid the payment of tax and is doing so dishonestly. But the Court of Appeal just said, well, where's that set out in the legislation? The next case study, a similar type of situation, planning, probably one of the most technical offence areas you can find. The defendant was the sole owner of a company which was right next to Bishop Stortford Football Club. And he owned the land right next door to it and had planning permission to use that land for match days. Sought an application to use that same land as a park and ride for Stansted Airport. That application was rejected by the local authority. Defendant thought, well, what the hell, went ahead anyway, and made £5 million out of that. On the way, he managed to ignore one set of enforcement notices for which he was prosecuted and convicted, and then a second set of enforcement notices for which he was prosecuted and convicted. Now, second time round, the council had had enough of this, and so they sought confiscation proceedings. Now, the actual income itself, though, of that £5 million, hadn't really been spent on giving him a lavish lifestyle. Most of it had gone to prop up Bishop Stortford Football Club, which was in definite need of being propped up at that time. And a lot of it had gone to employees. The park and ride itself, the business, was run legitimately. It paid its taxes, it paid staff, and so on. There was some money that went to the defendant as the shareholder of the business. But the actual main income went to the club and propped up the club. It was 30% of its income. Now, the personal gain from all of this for the defendant was $125,000 over about 5 to 6 years. So he was getting about $25,000 a year out of it. But most of it was being spent on the expenses of the club. So what was the sum confiscated? That's Bishop Stortford, the main stand there, obviously, through the proceeds of crime. But option A, should all of the benefits or all of the income received by the company that he had owned and channeled all of this through be recovered? That was the full $5 million. Or should it only be any of the income that actually came into his hands through his account, which was 1.8? Or should it be just simply that 125,000 figure, which is what he'd actually got out of it? Well, answer B, somewhere in between the two. It certainly wasn't what he'd actually got. It was all of the income that had come into his account. So why? Well, the case is Del Basso. It's a strange case in the sense it appears quite harsh. I think actually the Morgan case that we've just looked at is harsher. But the court approached it on this way. They refused to treat him and the business as the same. They refused to pierce the corporate veil. And I'll deal with the corporate veil in a moment. But they refused to deal with him and the company as though they're the same, even though he was the controlling shareholder. And so it wasn't the full 5 million. But what they weren't prepared to do is to look just simply at what he had gained out of all of this, net of paying off employees, tax, and so on. The legislation looks at the property coming to an offender which is under his control. Maybe temporary, but it was under his control, and doesn't care about the subsequent distribution, however laudable may be its intention. So what's the impact then of these types of cases on regulatory law? Well, where the outcome, as the court were looking at in Morgan, is the belief that either the business or the activity is unlawful, illegal, then in those circumstances, as long as the revenue is being derived or a pecuniary advantage being derived from that activity, which will encapsulate quite a lot of cases, then confiscation might be appropriate. One can see the example, obviously, of Del Basso was acting in breach of an enforcement notice. If you continue trading in breach of an enforcement or perhaps prohibition notice. Unlicensed activity outside of a permit, well, that's probably more to do with the environmental field, but equally there can be other aspects, licensing, asbestos licensing, things like that. Activities or contracts that have been based on fraudulent misrepresentations. So that's all the consumer trading legislation. It doesn't need to be the Fraud Act. It could be the Consumer Protection from Unfair Trading regulations, all stuff that previously has been viewed to be very much regulatory in character, and harassment under the duties under that as well, and perhaps, and has been argued on a couple of occasions, perhaps in the health and safety context. In a case that I did last year, which was a manslaughter mixed with health and safety offences, the prosecution, had they won, sadly they didn't, but had they won and convicted the co-defendant company, they were going to seek confiscation on the basis that the contracts, it was to do with a carbon monoxide leak from properties that this company had carried out the contract work for. And they were going to argue that all of the revenue that the company had derived from the contract should be confiscated, recouped, on the basis that it was an illegal activity because their work was fundamentally unsafe and in breach of the Health and Safety at Work Act. Now, sadly, we never had that rehearsed because my client was acquitted and so was theirs. So we didn't get any further than that. It seemed to be a much harder argument to run. One can quite easily see in the more types of economic regulatory offences that the prosecution are really looking to prove that causal link between the offending and actually deriving a benefit. And that's going to be quite a bit harder in circumstances dealing with safety prosecutions. Interestingly, the issue is arising and is being questioned, certainly in the media, about News International and issues to do with the phone hacking as a consequence of their management and so on, as to whether the business itself may be exposed to confiscation proceedings. But the difficulty there is going to be being able to prove what revenue or what income has been derived from the illegal activity. And I think that's going to be a problem for transferring this to health and safety away from the environmental or the consumer sector. But it gets worse. I mean, this isn't a happy story for companies anyway, or directors, because the court, as I said earlier, can restrain a business from dissipating assets even before that person has been charged with a restraint order. And all that the prosecution need to do is prove that there's a criminal investigation underway and that there is reasonable cause to believe that there's benefit from criminal conduct. So a prima facie case. And that puts the defendant, or putative defendant, in quite a difficult position. Ordinarily, you would not want to put forward evidence until you have an interview. until you see the prosecution case. But in these circumstances, there's almost an impetus for the defendant to come forward and say, well, there isn't a reasonable cause to think that I've benefited from criminal conduct for these reasons, and to seek to rebut that prima facie case, because if you don't, then a restraint order could be imposed. The counterbalance to that is that it mustn't be a fanciful risk that there's going to be some dissipation of assets. And probably one of the best pieces of advice to those who are companies or directors that are suddenly the subject of a criminal investigation is don't suddenly start moving assets around left, right and centre, because that could trigger the imposition of a restraint order, or certainly, if one is being planned anyway, will serve as good evidence to support the prosecution in that. Because one of the key restraints on the restrainer is where there is an opportunity that has been had by the defendant to dissipate the assets that they just haven't taken up. So if after the investigation was launched, there hasn't been any moving of assets left, right and centre, then the defence would probably have a reasonable argument, or certainly the court would put under great scrutiny, a prosecutor saying, well, there's a real risk here that unless we have this rather draconian application, then you're going to effectively lose all of the assets from future contribution proceedings. And the case of Windsor makes that quite clear and emphasises the draconian nature of it. But what the prosecution have to show is that the person has derived a real benefit from the criminal conduct. It might be quite difficult for them to show that in many cases, but where it's particularly pertinent to regulatory cases is that very often the prosecution will seek to say that the corporate veil should be lifted if they're looking at a director, to treat the company's benefit as being the director's benefit. And that's something I'm just going to come to in a moment. But before I do, in terms of the effect of a restraint order, it prohibits the recipient from dealing with any property. That property is any property, any free property. It doesn't have to be connected with the offence. And the court may make any order it wants to make sure that that's effective. And although the defendant can apply to discharge or vary the order at any time, as I say, the prosecution need only demonstrate a reasonable cause. Now, the order may make provision for reasonable living expenses so that somebody can obviously pay the bills during the period of time. But what it doesn't allow for is legal expenses in relation to the offence. And that is obviously quite a damaging impediment for somebody under such a restraint, is that they can't spend the money that has been restrained, the assets that have been restrained, in order to defend themselves as part of those proceedings. And the courts have said, well, legal aid's available for this type of case. Not very heartening for most people in this room. I don't think many will be on legal aid rates, and that is a problem for many defendants, particularly directors who are facing these types of proceedings, who are restrained. In terms of relationship with a fine, if it goes that far, generally confiscation will actually take precedence over the fine, so you'd have the confiscation first. And that's the analysis. The Innerspec case was different. There, for public interest reasons, the Judge Lord Justice Thomas said, well, where there's a considerable public interest in the fine, then that should be key, because in that case, the confiscation would have been in the sum of £100 million for Innerspec, whereas the fine they got was £8 million. So they couldn't have paid more than the fine of £8 million, and so it would have just wiped out any fine. And it was more important that the fine be imposed. And that may well be something that would be equally paramount in some regulatory cases too. So what arguments can be made? It's not all bad news. There are arguments, and the first one is that obviously there hasn't actually been a gain from the criminal conduct, and so to confiscate would essentially be another way of imposing an additional fine over the fine that is to be imposed in any event. The Savaraman case was to do with an employee of a garage. The garage had been dishonestly evading duty on diesel deliveries, and Mr. Savaraman was an employee, and it was felt that he wasn't actually getting the gains from the business, and so it would be wrong to seek confiscation against him for a certain amount of those assets. The other argument is that you shouldn't lift the corporate veil in relation to directors. The other argument has been that there's been a full restoration of the benefits obtained. Hurst House was due to a forged will in which actually the forgery had been appreciated before the estate had actually been administered. And so nobody had lost anything. The estate was administered normally. Quite incredibly, a judge in the Crown Court ordered confiscation of half of the estate, somehow, to the forger. The Court of Appeal said, well, that's ridiculous. There's been full restoration. And then finally, and this is probably the area where there's going to be most argument, is in relation to this Supreme Court decision of Wire, in which the court made it clear that really abuse of process for Proceeds of Crime Act cases is not the avenue. There is this argument on the Human Rights Act and proportionality. The judge does have a residual discretion, but it is exceptional that if the order is going to be disproportionate, it shouldn't be made. So piercing the corporate veil, this is something that has caused a considerable degree of litigation over the years, and is something that we've come across in the regulatory scheme a few times. Very often, when sentencing a subsidiary company, the judge looks at the subsidiary company with very little assets and says, well, yeah, you've got a massive, great parent company sitting in the wings. I'll have a look at the assets of that parent company. Well, the case of Prest is now pretty much decisive on the issue of the corporate veil. It's a family law case, a family law decision, but it went to the Supreme Court. And what was happening was that in that case, the wife, Mrs. Prest, was seeking to get all of the companies that Mr. Prest owned in this country. He lives in Monaco and was making no attempt to engage in the proceedings. And so the family court was very keen to order ancillary relief and to ensure that that was effective, allow her to be able to get the assets of those companies. And the companies complained, the only controlling director was, of course, Mr. Prest, but the companies complained that they were a separate legal entity to Mr. Prest, and therefore that order couldn't follow through. And in fact, over the years, the family courts have routinely allowed the corporate veil to be pierced in this way in order to avoid those parties seeking to evade ancillary relief orders in this way. And what the Supreme Court concluded was that that was wrong. There is no separate approach to the corporate veil and piercing the corporate veil. This is a fundamental aspect of company law and insolvency law, and it applies across the board. And what the corporate veil is that a company is distinct from its shareholders and has rights and liabilities of its own which are distinct from those shareholders. Its property is its own and not that of the shareholders. And whilst a lot of that sounds obvious, what that means is that the company's property, a subsidiary's property, is not the property of the parent company. And in fact, actually, the courts have been very rigorous in upholding this over the years, so much so that a director can't even insure his right insure assets or shares or shareholding as an insurable interest, because the courts have said, well, you have absolutely no interest, equitable or legal, over the assets of the company. You can't insure the assets of the company. All you have as a director is a share in the profits, or if the company is wound up, a share in what is realisable after that process has taken place. But you don't have a share in the property itself. And so it is wrong to treat a director as having the assets of the company. And in order to do so, you've got to, as it said, pierce the corporate veil. Now, the leading judgment was the new ex-Abramovich brief, Lord Sumption, obviously looking very happy after the Abramovich trial. And he gave his first leading judgment, which was the main judgment which most of the Supreme Court went with. He said, there's two principles. The corporate veil can be pierced if there was a legal right in the first place and all you've done is interpose a company in the way of that legal right to frustrate it. Now, that's evading what was a legal right against the director or against the subsidiary company or whoever. Now, that is piercing the corporate veil. It will be allowed, it's right, but it will be only in extremely exceptional circumstances that you can prove it. The other aspect is not piercing the corporate veil at all. It's the principle of concealment, that if you've committed a criminal offence or have assets You can't just simply put a company in front as a means of a buffer to actually hide the fact that you committed that offence or you have those assets. And that's not piercing the corporate veil at all. That's just concealing or trying to conceal that which was otherwise detectable. Now, the case of Sale, again, July case, has been a recent case to do with corruption, but it has a parallel to many other regulatory cases. This was a case of bribes in order to obtain contracts. And you can see that in many ways, contracts could be obtained by misleading representations or other matters accepting consumer trading law or equally environmental considerations. Now, in that case, the MD had bribed one company, somebody from another company in order to secure large contracts. The question was that MD liable for a portion of his salary and dividends from those corrupt contracts? Or was the director liable for all of the turnover that his business had achieved from those contracts? Now, the contracts themselves were legitimate. They had been acquired through a tendering process that was corrupt. But actually, once they're underway, his company did the job, his employees did a good job. There was an entirely legitimate series of contracts. Now, was all of the revenue from the business something that was to be confiscated from him? And the court said yes. The court pierced the corporate veil, or said that they weren't actually involved in that process, because he was the sole controller of the business. There was a very close relationship between him and the business. They were essentially indivisible. And what the company did was serve to hide what he was doing. So he was liable for the entire revenue in terms of confiscation proceedings on that basis. Now, is that right? Concealment within the law is really looking at using the corporate structure as a device. He wasn't really using the corporate structure. He was committing the crime himself, and it's simply that his company was reaping the benefit of that. And so what the court was actually doing was piercing the corporate veil. It was treating him and the company as indistinct. And previously, the Supreme Court has really sought to say that in those types of circumstances, if you're looking at a company being a vehicle for criminal activity, it's got to be in the way that it's structured, its personality. The device it's being used is to conceal the true facts. Now, it might be arguable in that case that because the company had, on the face of it, legitimate contracts, it was concealing what was underneath, which was corruption in acquiring those. And I suspect there may be a lot more arguments, or a lot further arguments in more traditional regulatory cases where what the company is doing is transparent. It's depositing waste on land, perhaps illegally. It is making false representations in order to get consumers to sign up. It is not notifying under the CDM or whatever. But in most of those cases, it would be difficult to say that the company is concealing what is being done by the person. And then finally is the fallback argument, which was deployed in Sale, of disproportionality. In the end, the court pulled back from making him pay the full turnover of the company because it relied on the fact that this would be disproportionate. And it made him pay and said his personal benefit that he derived from it, the business profit, not the turnover, and any pecuniary advantage from increasing market share. Nevertheless, obviously much more than he had actually acquired in his pocket as a consequence of the offending. And what has recently been said, it's been questioned whether Del Basso, that case on planning, is good law because of the basis that it may be argued to be disproportionate. And so really the argument going forward in terms of the future is probably going to be on proportionality. But one can see from those cases, from Morgan, from Del Basso, that it's not incredulous anymore that regulatory cases will come before the courts on confiscation proceedings. But what is going to be important is, since the case of Wire and these arguments of proportionality and piercing the corporate veil, that this is actually going to be something that's going to result in a lot more further litigation. The rush of litigation we've seen since Wire this year is going to be continued, and particularly if regulatory cases are included within that ambit. So there may be a silver lining at the end of this tale. Thank you very much.